Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Itchon, COO, and with me, as always, is Tim Anaya, Vice President of Marketing and Communications. So the big news from Sacramento is that SB 770, the single-payer bill sponsored by Senator Wiener, passed. And for listeners who might not be familiar with the intricacies of that, that's to try to secure a waiver from the federal government to spend federal dollars earmarked for, or Medicare and Medi-Cal, as it's called in California, to finance a single-payer system. So, Tim, what do you think? Is Newsom going to sign it? Probably not. What's your take?
Well, what was interesting is that at the California Democratic Party convention over Memorial Day weekend, some of the far left activists who were proponents of single payer actually heckled him during his speech, calling him out for not taking a more active role in promoting single payer. I don't know where he's going to come down on this. Given the deficit, that's an easy way for him to put the brakes on this proposal. Gavin Newsom likes to have his cake and eat it too. So he can say a lot of things in his record where he's been supportive of single payer. He created the single payer commission. He's publicly endorsed single payer. That's probably about as far as a would-be presidential candidate wants to go. This bill, as our Sally Pipes has said, this is really a stepping stone approach to single payer. It's really more of a backdoor approach to single payer. We'd still have to have another fight over single payer to enact it, but I can't see a President Joe Biden embracing this, even though Javier Becerra, the Secretary of Health and Human Services, is a single-payer proponent. But I can't imagine the administration would go for this, certainly heading into an election year. So I think a combination of budget deficits and presidential politics may put the kibosh on this particular measure. It very well could be that it passes both houses of the legislature and goes to the governor's desk. The other wrinkle here is that we allegedly will have a new speaker of the assembly in between now and the end of session. We're supposed to have Speaker Rivas by the end of June. So what does he think about single payer? What does he think about this bill in particular? That will also factor into the bill's fate.
For listeners, this is not a single payer bill, but it creates the financing mechanism to fund a potential single payer system. And we've had single payer bills before, but none of them really figured out how to pay for the exorbitant cost of a single payer system in California. And this sort of takes steps to try to work that out, even though we think it's going to be crazy expensive and unworkable. This is actually a plan that is supposedly, according to the Democrats, a potential path to get us there. So it'll be interesting to see what happens. Of course, the other big thing happening in Washington, Tim, is the debt ceiling. Tim, this is like deja vu all over again. It's a mad scramble all the time. What's different this time? What do you make of it?
Well, I think you're right that it's kind of the typical thing. And it's something that we've seen in these types of debates really over the past 10 or 15 years. It is easy to sit from the sidelines and jeer and complain about all the faults in a big, quote, deal. But as I've seen up close, try going in the room and negotiating and see how far you would get demanding, we're going to force them to do this and force them to do that. You would force them to do nothing. Because keep in mind, you're coming in with what you want to do, and the people across you at the table, they don't want to just do the status quo. They want to do the exact opposite that you're doing. Yes, of course, if fiscal conservatives ruled the day in Washington, we would have a very different budget and we'd have a very different approach to the debt. But I think it's rather remarkable, given what was at hand here, that this deal was able to come to fruition. It kind of reminds me years ago when we had a big, really budget crisis here in Sacramento during the 2008-09 period, when we were something like $40 billion in debt, which at that time was, nearly half the state budget. And the legislative leadership of both sides and Governor Schwarzenegger came together and negotiated a painful budget for everyone. And one of the things in that budget that I'll never forget was Republicans actually negotiated $16 billion in spending cuts. Can you imagine cutting $16 billion of spending in California, given our $300 billion budgets these days? And it was actually those who I'm sure are the most vocal critics today of the deal that Kevin McCarthy came up with in Washington. They were the most vocal critics of all of those spending cuts. And they actually made Republicans put back $1 billion because they said it, quote, cut too much. So I kind of view these folks in the same light as the critics of today's deal, that it's a lot of hot air and you want to get attention and TV time and maybe see if you can make a move on the leadership. But at the end of the day, you're not the ones who had to do the heavy lifting and go in the room and actually make a deal.
Well, how do you think Kevin McCarthy will come out on all this? You worked for him. I think that he's either going to come out very, very well if a deal goes through, or if the chance, and I think it's a very slight chance, that we would default, that it could be in his hands. So do you think that there will be an end to this impasse?
Well, I think that some of it's media spin. Some of it is, these folks who want to see themselves in the headline. You could, of course, file a motion to vacate any time under these new rules. But at the end of the day, you can't replace someone with no one. And no one has stepped forward, to offer themselves as a plausible alternative. From the moment he got elected in the great 15 round of voting, Kevin has surprised a lot of people. And I think he's been quite good, quite unifying, quite effective speaker, which, and there was always the knock on him. This is not a policy guy. Well, it doesn't get more policy than when you're negotiating directly with the president of the United States one-on-one over a deal to prevent the U.S. from going in default. So it's a lot of hot air. It drives clicks to his critics. It drives fundraising for his critics. They actually wouldn't know what to do if they suddenly got the throne and they were in charge. And they don't want to own the problem either. That's the other thing. They want to jeer about it and complain about what's being done, but they don't want to have to own the U.S. going into default. They're happy to have other people do it, and then they can complain about it too. So I think it's all overblown, and he is going to be the speaker for the next 2 years, and then we'll see what happens in the election.
Well, interesting times, Tim. So speaking of other interesting times, this is the season where the U.S. Supreme Court puts out its major decisions. And our next guest is Erik Jaffe, who is a legal counsel at PRI. Tim, you want to go ahead and introduce Erik and chat about some of the cases that you go through with Erik in this go-round?
If you have action before the Supreme Court, Erik is your guy. He is one of the smartest guys when it comes to Supreme Court and litigation before the court. And it's one of our favorite podcasts every year when we have him on for our Supreme Court preview, because as listeners may know, all the big decisions are handed down by the end of June. And we actually have gotten several decisions that have already been handed down. So we talked through some of the ones that have been handed down to date, especially one that didn't go our way that we've been following on Prop 12 and, whether California's requirements on pork production will apply to other states. And then we talk about some of the other hot cases that are going to be handed down this month, including things related to tech and things related to redistricting. There are a host of very interesting cases that could really affect people's daily lives. So we go through all of those cases and even some of the cases that you should be watching, but you aren't. So if you are a Supreme Court watcher and are interested in what the High Court's going to do, stay tuned. You are going to get quite the preview from Erik.
Thanks so much, Tim. And thank you to Erik and Tim on a great interview. I think you'll enjoy it.
Erik, welcome back to Next Round Podcast.
Thank you. It's great to be back.
Well, it's great to have you here for our annual preview of all the hot cases that the Supreme Court will be ruling on before the end of June. And I thought we'd start with a couple of cases that PRI has been very interested in. And interestingly, the court beat us to the punch and they've already decided on them. One of the big ones we've been following was National Pork Producers Council versus Ross. And that was a case that was decided last month that we've done a lot of work on. And it involved the impact of California's Prop 12 relating to the sale of pork from California on other states. And unfortunately, things didn't go our way on this one. So what were some of the legal issues in this case, and what do you think the impact of this ruling will be?
Well, I was disappointed also. Obviously, I had a brief in that case as well for the North Carolina Chamber of Commerce Legal Institute and the North Carolina Pork Producers and Farm Bureau and a bunch of other folks. And, you know, it, it was always an uphill battle because the conservatives are very skeptical of the Dormant Commerce Clause. The Constitution gives Congress the power to regulate commerce, but it doesn't expressly take it away from the states. Now, I think that was always the original understanding. I think the 10th Amendment kind of takes it away from the states, if you read the 10th Amendment closely. But, enough of the folks at the court don't agree, at least not yet, about that, and are very skeptical of what they, I think, correctly view as judicial policymaking. So they found a very narrow dormant commerce clause that at best applies to affirmatively discriminatory treatment of other states' goods, but that would allow sort of a across the board ban on goods that states don't like for one reason or another. The decision was a little funny, however, because it was so fractured and so many differing opinions that it's hard to know which one's controlling. There were a few points here and there that were controlling. I think they all agree that the Dormant Commerce Clause itself doesn't implement a so-called extraterritoriality principle separate from discrimination against another state's commerce. I think they all agree that judges need to be very careful when balancing one interest versus another, a state's interest in moral regulation, which is that issue here with the pork thing, or perhaps with foie gras, as you've seen in the past, or even things like blood diamonds, versus the economic interests of the folks who sell different products who may not think that they're immoral. And the court was very skeptical that courts are in a position to balance those kinds of interests, one against the other, that's more of a legislative function. And the court sort of left open a tiny window of maybe the Dormant Commerce Clause covers stuff other than active discrimination against commerce, or perhaps sort of protectionist behavior that tries to protect domestic industry from competition against foreign, not foreign, but out of state industries. But even that, the court seemed to suggest that it would take a pretty heavy burden of proof to show that it was worth going there. The court relied a lot on what it viewed as the deficiencies of the way the complaint was worded in this case, and it relied a lot on some concessions that there was no discrimination. I don't think either of those rulings was required, but the court found, a lot of members of the court found fit to go there. What I will say is, in terms of the implication, it means that a lot more states are going to be trying to implement their social policy via commercial regulations, and a lot more courts are going to be reluctant to strike those down, and the battle ultimately will have to shift to Congress and to state legislatures. So when I say more states are going to start implementing social policy, you can expect to see things that say, you may not sell goods that aren't fair trade. You may not sell goods that made by companies that don't provide a reasonable minimum wage. You may not sell goods that are from companies that do trade with countries that we hate, like Saudi Arabia or China or Russia. And you'll see individual states making these calls. And I think you will ultimately see even the more comprehensive, social issues like abortion. We will not let you sell goods from companies that pay for abortions. That'll be an interesting question. I'm sure some states will try to do that. And whether or not those things ultimately get struck down, I think it's going to be a close call. I think courts will be reluctant to strike them down. And I think ultimately this will become a political football, and hopefully Congress will step in. That's the consequence. But for California specifically and pork specifically, I think the real consequence is the price is likely to go up. You'll see a restructuring of the pork market to try to accommodate California's demands. Whether every pork producer does that or some pork producers sort of specialize in California compliant pork remains to be seen. But like with, organic food, it'll cost more to consumers to get California compliant pork, is my guess. And that's certainly the likely outcome.
Run to Costco now and stock up and put it in your freezer.
Yes. Now, the one thing I didn't mention, by the way, was Justice Kavanaugh's very interesting opinion, separate opinion, saying that while he doesn't necessarily think the Dormant Commerce Clause covers some of the issues in this case, he did think it was a possibility that other parts of the Constitution that have sort of been neglected over the years might, in fact, do a lot of the same work. In particular, something called the Export-Import Clause, the Full Faith and Credit Clause was another possibility. And I think he mentioned the Privileges and Immunities Clause, or Privileges or Immunities Clause. And each of these might do some of the work that the old Dormant Commerce Clause used to do, but perhaps have a better textual hook for that. And he sort of invited people to bring those claims. That will be a fascinating evolution. It will take a bunch of cases to get there and a lot of years, but at least it may sort of pick up some of the rationality that was lost when we abandoned those earlier clauses and shoved it under the Dormant Commerce Clause instead.
So in another case, Sackett versus EPA that our Pam Lewison has written about, the Supreme Court sided with private property rights in a complicated ruling involving enforcement of the Clean Water Act and the so-called Waters of the United States regulations. So tell us a little bit about the issues involved in this case, and how do you think the ruling will impact the Biden administration's very aggressive environmental regulatory push going forward?
Well, so the case is interesting. This has been a problem for many years, where the Constitution allows Congress to regulate commerce. It allows Congress to regulate navigable waters, and between those two, that covers a lot of water in the United States. It allows certain cross-border regulations. But in the Clean Water Act itself, it used this funny phrase, waters in the United States. And the question is that intended to be the maximum amount of congressional regulation? And it was always sort of unclear what constituted the waters of the United States and how you balance that off against sort of local regulation of local streams and local waters. And whether that meant like every puddle that collects after it rains, every drainage ditch versus, just sort of things that everyone would consider navigable waters in the United States, say lakes and rivers and, serious things where, of course, you want Congress to regulate a river that runs through 7 different states. Who else is going to do that? A big lake that abuts multiple states like Lake Michigan. Yes, you want Congress to have control of things like that. But do you really want Congress regulating every drainage ditch on every piece of property in the country? That seems excessive. And so it was always a big fight where Congress would say, well, everything is waters because it all is one big, aqua system where, the water in the ditch runs into the lake and it runs into the air and it drops into the ocean and the knee bone's connected to the thigh bone. And if you pick your nose, a butterfly over in Canada will drop dead. There was always these sort of convoluted everything's connected theories that ultimately meant Congress was regulating everything. And the court was always very uncomfortable with that, as well they should have been. And so they finally decided, I'm sorry, we tried to sort of take a middle ground. We tried to give you something, but not everything. And you just kept taking advantage of it. So now we're going to read the statute in a way that has some rational limit on it and is not a do whatever you want kind of statute. And I think that's a good thing. Whether or not the court drew the line in exactly the right place is open to debate. But again, like with the Commerce Clause stuff that we talked about just a minute ago, at the end of the day, the court is interpreting a statute that uses a very vague language, the waters of the United States. And so at the end of the day, if Congress doesn't like the line the Supreme Court drew, it could try to draw a more rational line. And if it draws a line that makes some sense, that's probably well within its power to do that on the margins. But if it draws a line that says we intend to regulate everything that the Constitution possibly allows us to regulate, no matter what, every day, every time, then they start risking the court having to decide what the constitutional limits are, the outer bounds of the Constitution. And that's always a dicey prospect for Congress, for the court, for everybody. So I think what you will see is an initial narrowing of what administrative agencies, the EPA in particular, can get away with what the Army Corps of Engineers can get away with in terms of regulating under the Clean Water Act, and perhaps eventually a legislative effort to pick its own line that justifies a slight bit more regulation than perhaps the fairly narrow ruling Supreme Court handed down would justify. Supreme Court basically handed down a ruling that says big bodies of navigable water and things that have a direct surface connection to such stuff. So if I have a river and there's a pretty continuous stream that runs into that river, okay, I may not be able to run my cruise ship down the stream, but the stream is connected to the river by surface water that is pretty much always there, absent a serious drought or something like that. That will be considered sufficient for Congress to regulate, but your periodic drainage ditch that the water runs off from your land for a day or so after it rains heavily, but then disappears until the next big rain, that's not going to be regulable. That's not going to be a wetland. And so Congress doesn't suddenly get the right to regulate every farm and every bit of construction on every piece of property. And I think that's really where they're trying to draw the line. If it connects to real navigable waters and could impact the use of that navigable water, great. If it's incidental and it just happens to be, yes, it rained on my property, no, that's not a federal regulatory interest.
Well, as our listeners who've heard our past podcasts with Bartlett Cleland will know, tech has certainly been a thorny issue for policymakers, and it's becoming a thorny issue for the court. And we saw some interesting rulings handed down recently. One of them, Gonzalez versus Google, tested the limits of Section 230 about whether tech giants are aiding, abetting terrorists by allegedly promoting their content online. And in this year's cases and others that are on the horizon, the court is going to be sifting through a lot of cases that will ultimately decide the liability of online companies for a host of different types of content and whether these state and federal restrictions that are being enacted on online content are legal. So share with us your thoughts on the court's ruling in the Gonzalez case and how you see the court sorting through these tech-related issues going forward.
Sure, of course. So the Gonzalez case itself was sort of a big wind-up and then no hit. But when considered in connection with the Twitter case, the two of those together had a little more meat on them. So so Gonzalez dealt primarily with the 230 issue, whether Section 230 immunized Google via YouTube, but Google ultimately, from suits for this aiding and abetting question on terrorism. Apart from what the terrorism statute itself said, Twitter had the separate question of whether Twitter's conduct by letting people retweet and whatnot was in fact aiding and abetting. And so the court ultimately decides the Twitter case by saying, if you just treat the tweets and all that stuff the same as you treat everyone else, it's not like you went to ISIS and said, hey, ISIS, let me help you expand your reach so that you can blow up more buildings. Right? It's not like you actively cooperated with them in a terrorist enterprise. You just were basically a public utility where they used your service the way somebody would use a telephone or a cell service or the mail or what have you. They said that's not aiding and abetting under the statute. So that even if you could go forward with your claim, you would lose, is what the Twitter case said. And then when they got back to the Google versus Gonzalez case, they said, look, it's an interesting question whether 230 means you can't even bring this claim at all. But since we just decided that your claim is sort of trash and and you would probably lose given your allegations and what you sort of said it was the same as Twitter, and we just said that the Twitter case loses, we're not going to reach the 230 question. So we're going to duck for now, and maybe it'll come up later in a case where it matters, but it doesn't really matter here because their claims are not valid anyway. So for everyone who briefed the Google case, that was a little bit of a, you were waiting for a big decision on Section 230, and then what you got instead was, maybe we'll wait and decide that some other time. But for now, we don't need to. And while that is true, and it's a properly sort of cautious judicial approach, it is, of course, very disappointing for the hundreds of people who filed briefs in the case and were looking for some clarity on what the heck 230 did and didn't cover. But, it's hard to fault the court for not deciding something they didn't have to decide. It would have been nice. It would have provided clarity. But many of the briefs, mine included, sort of pointed out that, look, this is something that Congress could change whenever it wanted. There are lots of bills being proposed on how to regulate the tech giants, and the court should just leave things alone as they are now and not sort of take away the immunity or narrow the immunity. Let Congress do it. And I think sub silencio, that's basically what the court did, is it said, we don't have to do this. Congress is looking at these questions a lot. So why don't we take a pause, see if Congress does anything, and maybe we don't have to stick our nose in this big controversial issue that's better dealt with by the political branches. And I think that's a fair, ultimately fair reading of that. Now, are they going to get away with ducking and covering on the other tech issues that are looming out there? The Florida statute, the Texas statute, some potentially new congressional statutes that change the immunity for the tech giants? My answer is no, I don't think they're going to be able to duck. I think you are going to see next term the court being forced to take up the Florida and Texas cases, one or both of them, about how much can you regulate social media entities, not necessarily consistent with 230, but consistent with the First Amendment, right? And I once explained to somebody that, look, 230 provides immunity for, against suits that are based upon the speech of others. It doesn't provide immunity based on your own speech, right? You're still liable for that, but you're not liable for the consequences in the lawsuits that are predicated on the speech of others. And the whole fight is, when does the speech of somebody else become your own speech? And that's a big question, not just for Section 230, but for the First Amendment, because the First Amendment becomes more meaningful when someone's trying to regulate your speech. So even though 230 is limited in its protections, where 230 stops, the First Amendment may start, or they may overlap a little bit somewhere in the middle, but 230 is not the only protection out there. And I think the Texas and Florida cases will certainly test the limits of that, of how much you can treat these online services as, regulable entities. And I think the big conceptual difference that they'll have to think about is, are those services more like magazines and the people who run those services more like editors who are sort of either editing a magazine or conducting a parade about who they let come join their parade and who they don't? Or are they more like public utilities, like the phone company, where they're basically a service that needs to be open to everyone without discrimination? And I think my answer is they're more like magazines and parades than they are like public utilities. But we'll see what the court says. The First Amendment will have a lot to impact on that. I think there'll be a lot of push to have more regulation. And the only question is, how can you provide regulation that doesn't run afoul of the First Amendment? And my suspicion is sort of consumer protection is the better path than sort of you don't get to discriminate against my viewpoints. Because, of course, if they're private entities, the whole point is I get to discriminate against your viewpoint if I'm private. It's only the government that doesn't get to discriminate against viewpoints. But I get to discriminate against viewpoints all I want. That's called freedom of association. That's called my freedom to speak and to not speak, or to edit, to include editorial things or to not include them. That's the old newspaper cases, basically. So we'll see. I think what you'll see is efforts to increase a little bit of transparency, inform users of what the rules of the road are so that they can make educated decisions about whether to use your service. And that's the consumer protection approach. But it's going to be a little harder to sort of affirmatively regulate these tech companies regarding the content of what they put up, unless the content itself is determined to be illegal. But if you just want to say you can't kick conservatives off, you can't kick liberals off, I don't think that's ultimately going to work out.
So, looking ahead, our Lance Azumi has written extensively on a case involving race conscious admissions policies that discriminate against Asian American students. And that case is Students for Fair Admissions versus Harvard. And there's also a companion case involving admissions at the University of North Carolina. What are some of the issues at hand in these cases? And what was your takeaway from where the justices, their comments for where they're headed? And how do you think a ruling striking down the admissions policies would impact those in California and potentially in other blue states who continue to try and enact these types of affirmative action policies despite the many legal setbacks?
Well, I think the issues are interesting. And just to clarify for listeners, of course, in the North Carolina case, that's a constitutional question. That's a state school. In the Harvard case, it's a statutory question. It's Title VII. So there's a statute that says you can't discriminate based on race. But the Equal Protection Clause and the 14th Amendment say a state school can't discriminate on race. So they're very similar, but they just have slightly different legal predicates. And I suppose they don't have to be exactly the same, but they'll be, in all likelihood, they'll be extremely similar. And what I think is interesting is, I think there will be an opinion that says we are not tolerant of racial discrimination. We do not think you get to discriminate on race. And just because you think you have a good reason to do so, we're not going to buy that. So I think the diversity arguments are going to not work quite as well. Certainly for a state school, they're not going to work as well. Whether or not the justices try to distinguish state schools versus private schools like Harvard is an interesting question. There's at least the potential to draw a different line, that Harvard gets to consider diversity, racial diversity, in a manner differently than a state school might. But I think they'll probably be similar. And then the real rub is going to be, so what do you do about outcome differentials, right? So in all discrimination cases, there's always been a difficult line to draw between purposeful discrimination, where it says, you're of a particular race and I don't want you, so I'm not going to let you in. I'm going to have a quota that says only 10 of you, only 10 Asians, only 10 Blacks, only 10 Jews, whatever it is. That's very overt, purposeful discrimination based on race. But what if I'm not foolish enough to say that out loud? Or I don't even mean to say, even mean to do it. It's just that at the end of the day, when I apply my criteria, there's a wildly massive imbalance between the outcomes, so that the outcome makes me suspicious that maybe secretly you are discriminating, or maybe you're applying some criteria that in and of itself is discriminatory. So if I said, you know what, I only want people from rural Pacific Northwest and nobody from big urban areas, well, you might think that that's the result of that obviously would be quite discriminatory against a lot of minority groups that live in big urban areas, but perhaps not in agricultural Pacific Northwest. And you might think that that's a proxy for racial discrimination, and you would look into that. But the court also has been skeptical of using outcome to infer intent. And I think that's going to be the interesting part of these decisions. They're going to be reluctant to sort of say, well, any imbalance in result proves racial discrimination. Because at some point, there's just variation in the world. And today I have 2%, tomorrow I have 5%, the next day I have 3%. Or there are other factors that will play out in a racially disparate way, but are not racial discrimination. So I'm much more curious to see how they get there than what the outcome is. So I think the outcome in this case will be that they think that Asians are being discriminated against and that that's not appropriate. And the fact that you're doing that in order to benefit other minority groups is not going to be considered a sufficient excuse. That's how I sort of see it coming out. Now, what does that do to California? My understanding is California already does not permit discrimination based on race, but it probably does allow socioeconomic considerations to be taken into account. So if you're a poor kid who had to hold down a second job while you were in school and you pulled a B+, that's like the rich kid who had a bunch of tutors who got the A-. That's not racial discrimination. It may be economic considerations that you're sort of saying the rich kid had it easier, the poor kid had it harder. And so if the poor kid can pull a B plus under tougher circumstances, I'm going to put a thumb on the scale that says that B plus counts just as much as that A minus and maybe a little bit more. And so I think you'll see places shifting to taking socioeconomics into account more than they take race per se into account. And my personal opinion is that that's all for the good. At the end of the day, the key difference is that race is immutable. You can't change it. And so once I say, I'm going to help this racial group, it's hard to unwind that. If you say, I'm going to help kids who had a harder time because they're poor, and I think that doing well when you're poor shows great strength of character and great work ethic and great this and that, well, that kid's eventually not going to be poor. So their kids aren't going to benefit from that in the future. So whoever's at the bottom of the barrel keeps turning over potentially and getting the leg up when they have to work a little harder. I think that's much more in tune with our democratic ideals. It's not an immutable characteristic. Poverty can be changed, we hope. We base our whole free market system on the notion that you can work your way out of poverty with a little bit of a helping hand. You can do well. And that version of affirmative action might be more both socially acceptable, constitutionally acceptable, and politically acceptable, because it's no longer what color are you? It's let me look into, did you have a tough time growing up? And that can apply to white kids, black kids, Asian kids, every kid. But it's not going to apply to the kid who grew up in a rich family with a lot of tutors, probably. And that seems to work for I think a lot of people will be more accepting of that, and it's more consistent with our constitutional ideals.
So there are several cases involving redistricting and the gerrymandering of legislative and congressional seats, the most prominent of which is Moore v. Harper. Now, observers have argued that depending on how the court rules in these cases, we could see a seismic shift in redistricting that could lead to significant changes in district lines before next year's election in 2024. So, based on these arguments and other recent rulings, where do you think the court is headed in these cases?
Well, in the Moore case in particular, the North Carolina Supreme Court vacated one of the decisions below. They're reconsidering the case. It throws everything up into the air, and so then the U.S. Supreme Court asked for a bunch of briefing on how does that affect the case before us. So there's at least a decent chance that the U.S. Supreme Court will once again sort of duck and sort of say, well, now that they've reconsidered at the state level and it may not be something we should get involved in just yet. I think it's 50-50 though. They might keep it. There are other issues that are technically still live and that, aren't mooted out by that decision. But once again, much like in the Google versus Gonzalez case, it may not be critically necessary right this moment to decide those issues if the North Carolina Supreme Court is taking these questions up and dealing with it differently. But assuming that they do continue with the case and make some of those decisions, some of the more aggressive theories about how even state courts don't really get to decide state law issues, I think would be a remarkable seismic shift, not just in how we redistrict, but in terms of how we conceptualize federalism and the relationship between different courts, and more importantly, state level separation of powers or lack thereof. So, there's a state constitution that says the legislature has to behave in X, Y, and Z manner. And if the legislature says, yeah, but given that this is redistricting, you don't get to apply the state constitution to us anymore, that's remarkable. That's a shocking conclusion. And I have a hard time seeing 5 votes for that outcome, for the outcome that says state courts don't get to interpret state constitutions, even as it applies to things like redistricting and voting. That would be quite the step to take. Now, I can see something that says, look, you don't get to disingenuously reinterpret what a statute says, because the statute says you have to do it on Tuesday, and you decide, I don't like Tuesday, I'm going to make it Thursday. You don't get to do that without a constitutional justification for it. You don't get to just decide willy-nilly. I could see something that says where there's real clear legislative rule, you don't get to change the rule unless you have a overriding constitutional justification for doing so. And even then, you may just get to say, I won't enforce the rule, but you don't get to write your own. So you could sort of see middle ground versions of this that would not be quite so aggressively transformative. And that's what I would look for if Moore goes forward. If Moore does not go forward, there's a case on deck for next year, the Alexander versus South Carolina NAACP, which deals with a whole bunch of redistricting issues, both dealing with what does it mean to be discriminatory, how do you separate, decisions based on race from decisions based on politics. I think those issues are sort of a little bit more concrete and immediate in terms of how you implement redistricting issues. And that's going to be very interesting. You've been seeing some of those issues being worked out in challenges to voting statutes, not just redistricting, but like the Arizona voting statutes. But, there were a whole bunch of redistricting cases that came down. So, race versus politics. If I discriminate because you're a Democrat, does that mean I'm discriminating against people of a particular race just because Republicans want to hose the Democrats? Maybe, maybe not. So far, we've generally said not, but it's sort of an interesting question that they're going to take up again. So ultimately, I have a hard time seeing a groundswell change in the rules. I can see sort of more subtle changes that would encourage legislatures to be more specific in their rules, that would limit how much a state court could on its own change a legislative rule, but some of the real implementation may have to happen at the state legislative level. I have a very hard time seeing the Supreme Court say, sorry, state courts, you may not enforce the state constitution. And your view of the state constitution will have to take a backseat to our view of the state constitution. That would be very difficult to imagine. So I don't see the sea change that some people fear. Maybe some subtler changes, but not that. And then next year we get to have some interesting debates over the South Carolina case.
So these cases, of course, are some of the highest profile cases being considered this term, but there are always some that don't crack through and get the media attention that they should. So what are one or two other cases that you've been following this year that you think are very important for people to know about, but haven't generated the media buzz that they should have?
Well, I mean, some of them have generated some buzz, at least in legal circles. There's a case called Loper Bright Enterprises, which is about monitors on fishing vessels, which sounds crazy and tedious and largely uninteresting to the public, except for two things. One, it boils down to a Chevron fight about whether the agency that regulates fishing vessels, how much discretion they have in interpreting their statutes when the statute's ambiguous. And Chevron, of course, is a big topic in legal circles and is a big part of, how much room does the administrative state and the executive branch have to sort of expand the powers they've been given. Congress gives them some general power or some vaguely worded statute says, go do X, and how much can you expand X? And I think that would be a huge case that's coming up. That'll be for next term, but it's already been granted. And that will impact a lot of things. I think there's a case this term that we haven't heard from yet called Creative LLC or Creative 301 LLC, which is about a website designer who had religious objections to designing websites, I think for gay marriage or something. I forget what the particulars were. But more, the bigger issue there is not the details of who was making the call and what they wanted to do, but whether an individual website is a creative speech activity, even if you do it for pay and gets First Amendment protection versus anti-discrimination laws. And this is a big issue that keeps coming up over and over and over again of the clash between sort of anti-discrimination public accommodation laws that say you may not discriminate based on race, sex, religion, ideology, sexual orientation, whatever you pick, pick your criteria, versus what amounts to freedom of speech and freedom of association. Well, if I can't discriminate against you because I don't like your politics, does that mean I have to associate with you if I engage in a business? What if I have a club that says no Democrats allowed or no Republicans allowed or no Trumpies allowed? Can I not have that club? Well, of course I can. Well, what if it's a coffee shop that says, the Che Guevara coffee shop, only communists allowed? And I don't want any of you, middle of the road statist Democrats or Republicans in my coffee shop. Can I do that? These are all things that sort of blend commerce with free association. And I think some of those questions might get answered in this Creative 301 LLC case, which is about an individual website designer who didn't want to work with certain people. Another case coming up that I think is interesting, that got some attention, but maybe not as much as it might, is this case called O'Connor, I think it's called Radcliffe versus Garnier. And there's another one, a companion case to that. And that deals with whether public officials who talk about their official activities on what are nominally private social media accounts can restrict access to those social media accounts and shut off comments for people they don't like or people who disagree with them. So basically engaging in viewpoint discrimination on what they call a private account, but which is used for at least some public related activities. So the example would be I'm a school board member and I talk about my school board related official duties on my Facebook account. And people can comment on Facebook or on my Twitter account for that matter. And people can comment, but I say only people who have nice things to say can comment. And if you don't like my behavior on school board, I'm going to block you. Now, if that were a government account, we would say that's viewpoint discrimination and is inappropriate. But now it's a private account that you use in part for private purposes and in part for public purposes. When does sort of a private activity become a public activity when engaged in by a public official? And once again, that line crosses all kinds of areas of the law. It was a line that you saw in some sense in the Bremerton School District case about the praying coach. Was his prayer at midfield after a football game, is that private religious expression, or is he engaging in behavior in the course of his official duties as a coach? And this is in some sense of a piece with that same question of where is the line between private behavior and official or governmental behavior. And because once it's governmental behavior, the Constitution, of course, kicks in. When it's private behavior, the Constitution kicks in the other direction and says, we protect the individual's choices in those moments. So that will be, I think, quite interesting and quite fun. I'm sure there are other sort of cases that only lawyers could love, but I'm not sure they're going to be that interesting to the members of the public. There are a lot of cases that are coming up that deal with sort of this chevron, how much room does the executive branch or an agency have to expand their own power and read a statute that we thought used to be narrow in a broad way. And then the last case, I guess, that is of interest to PRI, because I know I did the amicus brief for PRI in the case, is this case called Moore v. the IRS, or Moore v. United States, I guess, which is about what does it mean to tax income, right? So some rules a few years ago under the Trump administration taxed a company's growth in value as if it were income, even though you didn't sell the shares. So what we would call unrealized gain. And for the public out there, that means when you have your 401k and you put your money in and bought stock in Microsoft or Apple or Tesla, and that stock has gone up in value. So you see a nice big number on your 401k, but you haven't actually cashed that in yet. So you don't have dollars in hand. You just have stock out there that's really high today. It could be really low tomorrow, as we've seen over the last 2 years, 3 years, 4 years. What goes up sometimes comes down. And the question is, can the government tax you when it goes up, but you haven't actually cashed it in yet? And this Moore case, which is right now just a petition for cert that the court is considering at the end of this month, raises that question in a context that doesn't matter much to people on the call, but that if they take it up and decide it, could matter a lot to things like your 401k, money you invest in, other things like that. And for everyone, even people without tons of money, your retirement plans, your 401k, your pension plan, all of that may be connected to the stock market. And if we get to tax it before you actually have the money, that's a very different approach to the world than we used to have. So that's interesting and not really necessarily on the horizon yet, in part because the court hasn't decided whether or not to take it.
So outside the courtroom, the Supreme Court has generated news this session, although not much of it very favorable, on the issue of ethics requirements for Supreme Court justices. And some senators are even threatening the court to impose an ethics plan, while the Chief Justice promises an ethics plan will be implemented sometime soon. So how do you think the court will ultimately resolve this controversy?
I think what you will see is an effort to create a little bit more clarity, both for the justices themselves and for the public outside who views it, just so that people know. Some of these rules historically have been subject to a lot of interpretation. They've been interpreted different ways by different bodies. The administrative office of the court interprets them one way. Congress interprets it a different way for its own staff and its own members. And so you will see the court, I think, adopt something that helps provide clarity to members, to their own members of the court, and to the public, that I think will be a good thing. Because so much of what's going on now is really a function of confusion and innuendo, where people who don't see the court up close and personal in the same way as maybe practitioners do, are suddenly suspicious because there's all this noise and hand-wringing by members of Congress, who I won't name, and some of whom I hesitate to have their name anywhere near my mouth because it's too painful, but who I think are creating a tempest in a teapot in some of these instances, and are using it for their own political purposes. Which, look, they're a political branch. It's hard to fault them for, banging the table when they think it suits their purposes. That's what politicians do. But from lawyers' perspective, I think it's a little overblown. But I think some needed clarity and initiative from the court will probably help settle this down. And I don't really see Congress getting the support to pass a restrictive set of ethics codes on the Supreme Court. And if they did, it is not at all clear to me that that would be constitutional. So if you look at the Constitution, the Supreme Court itself is the only judicial body created by the Constitution directly. All other courts are created by Congress under the authority, obviously, of Article 3. But it says there shall be a Supreme Court. It'll have a Chief Justice, and all the other courts are and such other courts as Congress may create. So it's one thing to create a set of ethics for lower courts, but it's not clear at all that Congress could, consistent with separation of powers, could do that for the Supreme Court. Now, that being said, Congress's sole meaningful check on the United States Supreme Court is to impeach somebody who they think engaged in bad behavior. And I suppose they could pass a statute that said, this is what we consider bad behavior. And if you do this, we think this will be enough to impeach you. And that's nice and that's lovely, but it's mostly performative, right? It's mostly just a speech act rather than a real act, because you could never enforce the statute. In order to impeach somebody, you still have to get the House to vote and you have to convict in the Senate. So regardless of what the statute said about the Supreme Court, future members of Congress may not feel bound to impeach or convict under those circumstances. There would just be political pressure to do so. So will they do it? I don't see them having the votes just yet. Let's wait and see what the next election brings. If it brings a meaningful difference in the balance of power in Congress, sure, I'm sure we would see something. And then we would have some very interesting and difficult court cases where the Supreme Court would have to ultimately decide whether or not Congress violated the separation of powers by telling the Supreme Court what it had to do. That's a question that nobody wins from, it seems to me.
So Ro unfortunately wasn't able to join us for our discussion today, but she did send in a question for you. So last year, Leakgate was a very hot scandal in advance of the Dobbs ruling. Well, 1 year later, the court still has not identified the culprit in the case. So based on what you know and you hear around town, why do you think the leaker has never been found?
Well, I'll preface this by saying I have no inside information. I just have sort of experience of having worked up there and having obviously read the stuff that became public. And I think the reason it's hard to find who exactly is the leaker is severalfold. One, it's not like there was a great digital trail. It's not like this was done through an email from the court where you could trace the email. Two, with the onset of COVID, a lot of things changed and probably became a little looser, where people were working from home more. So more materials got home that in a previous era may never have been taken out of the building. And so, when I worked there, you weren't bringing stuff like that home. You were just staying at the court till midnight, 1 a.m. until your work was done. And that was that. But with COVID, where, people had to work at home and a lot of people wanted to work at home and nobody was going to risk, getting their justice sick and killing their justice. You had a lot more stuff going home. So there's a lot less visibility into who else might have seen that stuff. And nobody was really necessarily checking what left the building in the same way that they might have checked in the past. So if it turns out that lots of people brought the opinion home or materials relating to the opinion home to work on, how do you know who leaked it? You may have a pretty big pool of possibility, but so now you have multiple clerks, maybe multiple justices, maybe all the spouses or other people who lived in the house of those people who might have glanced at it or taken a picture of it or run a copy of it real quick when the individual didn't know. You have all kinds of people who delivered the mail within the court who could have taken a copy of it. You had printers at the court that only had a limited memory. It's just the technology at the court right now, and in many places, is just not sufficient to be sure. So whatever your suspicions are, you're not going to make an accusation like this unless you are highly confident you knew who it was. And the problem is there was a lot of innocent behavior that was risky and that they might want to address in the future, but that wasn't sort of intentionally designed to mess with the security of the court, but in fact made the court processes more porous than perhaps we would like. And I'm sure that will get fixed going forward with more processes by the court, but it's very hard to figure out in the past, given that if you looked at the opinion as it was posted on Politico or whoever, it was clearly a paper copy that then got scanned or photographed. So it's hard to track paper copies. Paper doesn't leave a trail in the same way that electronics does.
So finally, let's look ahead to the new Supreme Court term that will begin in October. What are a few of the cases that will be coming next year that we'll surely be talking about in our 2024 Supreme Court preview podcast next spring?
Well, a couple of them I already mentioned. This South Carolina NAACP case about redistricting that's already been granted. That's a big deal. That's going to cover a lot of issues, both in the redistricting context, but also in the election law context more generally. You have this public official private website case that we already talked about that I think will be very interesting. I'm fairly confident that we will see the court take up one or both of the Texas and Florida social media regulation cases. So that will be quite interesting. This big Chevron case, that could send shockwaves through the administrative states and through administrative law practice and executive branch functionings. That will be interesting if they decide to get rid of Chevron. I'm not sure they'll go quite that far, but they're certainly going to pare it back, is my opinion. So those are all some big upcoming cases. I imagine we will see a number of gun cases come up. There are a few that are sort of lurking out there, dealing with issues like bump stocks, dealing with issues like assault weapons, dealing with sort of some of these more restrictive rules about where can you carry a firearm in a city, what counts as a restrictive place. And I think some of these will find their way to the court in the next year, either, certainly on cert. And then the real big interesting question is, what does the court do with those cases? Does it take one of them up? Does it just deny them? Either version of that will be sort of a big deal, because even if it refuses to take the case, that sort of opens the door for states to get more aggressive in how far they push this. And I think we will see some kind of challenge coming up. That's the aftershocks of this pork case, where somebody tries to impose some social issue-driven regulation on trade that once upon a time we would have said is a dormant commerce clause problem. But finally, people below will start saying, well, let's see if this is an export-import problem. Let's see if this is a privileges and immunities problem. Let's see what else it might be. And so we might see something coming up at a preliminary stage, say an appeal from a denial of a preliminary injunction or a grant of a preliminary injunction that will be a big deal. So those are the things that I see coming up. I'm sure there are tons of other things that I'm missing. I'm sure there will be more election-related litigation in some of these election law cases. The 11th Circuit just decided a big case out of Florida regarding Florida's election law stuff, dealing with mail-in ballots and things like that. There's some material coming out of Georgia that may make it up there in time, a bunch of preliminary injunction motions. So we'll see a lot of activity right in the run-up to the election that I imagine may find its way to the Supreme Court as well.
Well, Erik, thank you so much. It was great chatting with you. I always enjoy our annual dive into the hot Supreme Court cases.
Yes, me too. Glad to give the preview. And I guess after the end of June, we'll get to see whether any of my limited predictions actually bore fruit or whether I'm just picking results out of a hat. It might be a little bit of both.
And follow us on social media. We'll keep track of all of these. So you will know when the hot cases come down.
All right. Thank you again. And until next time.
If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, TuneIn, iHeartRadio, and Spotify. And when you're on these platforms, don't forget to give us a big 5 stars. If you don't subscribe to any of these, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Itchon. Hope you'll come back again for next round with PRI.